We frequently have clients that come to us post-judgment. What that means is that the client already has a judgment entered against him or her. The company or person that holds the judgment we refer to as the judgment creditor, and we refer to our client as the judgment debtor. One of the biggest concerns that our clients will come to us with, and a question that is frequently asked, can I go to jail? Can I be arrested for owing a debt? The short answer is no. There is no such thing as a debtor's prison in the United States. However, the judgment creditor is entitled to certain information, and a tool often used by judgment creditors is what's called a fact information sheet. That fact information sheet gets sent to the judgment debtor, and the judgment debtor is required to provide information such as where the judgment debtor works, where the judgment debtor has bank accounts, and whether or not the judgment debtor owns any real property or personal property. A lot of times judgment debtors do not want to give this information up, understandably so. However, what many judgment debtors do not understand is that they are required to provide this information to the judgment creditor. If they do not, oftentimes the judgment creditor will go to the judge and ask that the judge order that the judgment debtor provide this information. Failure to comply with the judge's order or orders can result in the judgment debtor being held in contempt of court. And that could lead to the judgment debtor being arrested and possibly spending time in jail. So it's important that anybody with a judgment against them consult with an attorney who specializes in post-judgment asset protection.